Hello, I'm Judge Tom Moukawsher. I'm a retired Connecticut Superior Court judge, and this is Civility in the Legal Profession. Welcome, and look forward to an interesting review of one of the big problems we're all facing today. So let's begin. So I suppose the first thing we ought to ask when we're talking about civility in the legal profession is, what is civility? And I challenged with coming up with this course. I had to think about it a great deal, and I came up with a view that goes like this. I think that civility is recognizing the dignity and legitimacy of every person, even during intense disagreement. So who cares about civility? And I suppose the answer to that one is easy. And I'd say it's not enough people care about civility. I think that everyone should be concerned about it in the legal profession because civility, the rule of law and order, all go hand in hand, and we can't have them without each other. Now let's talk a little bit about background, a little bit about civility in my life. And I've worn many hats in the last 40 some years hanging around courts, and also was a legislator. And each of those experiences informed me about the power of civility and the necessity for civility. When I was a legislator, I was there in the House of Representatives in Connecticut, and also served in the governor's office, and got to see how the legislative process works over a period of some 17 legislative sessions in various capacities. And when I started in the 1980s, there were a lot of unwritten codes about how civility worked in a legislative environment, in the lawmaking environment, and how to make laws and how to administer laws. And there were certain things that you just didn't do. The expression used to be, "My word is my bond." And there were many friendships across the aisle between political parties, and many alliances were made about different issues that affected people. And everyone looked out for their constituents, but they also looked out for each other. This may sound unfamiliar to you today, and I wouldn't be surprised. As a lawyer, civility was a critical part of what I had to do, because I got to watch civility in action from observing my father's practice. My father practiced from the 1940s and into the 2000s. And he used to tell me how the courthouse used to work. And it worked a little more like this when I was practicing than it does today. But in the old days, lawyers pretty much did every kind of case. And they dealt with each other. The legal community was much smaller, so they dealt with each other all the time, every day, and with the judges over and again. And so they all knew each other very well. And they all knew that they had to work with each other. And so cases used to be hard fought. They used to be tried, almost always. They used to be tried, and there was a decision in them. And when the trial was done, or in the middle of the day, the lawyers would take a break, and everyone would go down to the club that was nearby the courthouse and all have lunch together. The judge, the lawyers, everybody sat, my father used to say, at a long table, and everything was put aside, and everybody realized that they had to live to fight another day. I tried to practice law that way myself. I knew that I had to get along with lawyers I was going to see over and again, and get along with judges. And I thought that civility was a critical skill as an advocate. And then I went on to the bench. And I went onto the bench after spending about 20 years in the more formal environs of federal court. And I was appointed to a state court position. When I had left state court some 20 years before, it would have been a surprise to find jurors who weren't wearing suits and ties to court. And when I got assigned to a tiny criminal courthouse up in Danielson, Connecticut, it was quite a shock to me to find the parties in criminal court showing up in flip-flops and cut-off shirts and shorts and flip-flops. And it was quite a surprise to me that the idea of the dignity of the proceedings had slipped. And with that dignity came a loss of some of the civility. There was less formality to it. there was less politeness among the lawyers and among the people who came to criminal court. And I tried to do something about it there and in my subsequent assignments by telling people that you can't wear flip-flop shorts or cut-off shirts in the court. And it had an effect. And I tried to set an example on the bench of what it meant to be civil. And also in the complex civil cases, the constitutional cases, and as I'll mention again in the near future in this discussion, in the all-important and difficult family court, which is the hardest place that I ever practiced or ever got to sit in as a judge. So let's go forward now and talk about what's happened since the days that I talked about, where civility in the, let's say, the 80s and 90s, in my experience, were stronger present in courtrooms and even, as I mentioned, in the legislature. There's been a decline in civility in our country. And it's come in private life, it's come in the media, it's come in politics, and yes, then it's come also in legal proceedings. And of course, it's the latter that we're worried about. But all of them affect each other. And I've often puzzled over exactly which one's the predominant source of this, in particular between private life and the media. Where does incivility come from? How did it get into our society in such a prevalent way as it appears to be today? Was it the TV shows that got crude, or was it we who got crude and was reflected on television? I don't think we'll ever resolve those things, but one fed the other, and that fed into politics. I think the last place in which incivility, the decline of civility, showed up was in the courthouses. And it took somewhat longer to get there, but it's there today, that's for sure. Let's go forward to talk about what it means, because declining civility is not just one of these things that we can sort of boo-hoo over and say, I wish people were nicer to me. The declining civility has real world impacts that we should all be concerned about. And that's because bad words betoken bad deeds. We're facing the destruction of a rules-based world system and the destruction of a rules-based domestic system. Now, what do I mean by this? Bad work is betoken bad deeds, and because what happens is disrespect, incivility toward a person often is followed by the insults, and the insults are followed by the threats. And when the threats don't work, actions happen. Those actions can take place in court in various ways that lawyers know how to harass each other. But in the real world, this incivility, where bad words betoken bad deeds, often ends up in violence. And it's a progressive thing that I believe that civility in our society, and for us, civility in our courts, helps hold that together. That lack of civility has created a lack of respect for rules-based systems. And that's included in world affairs, where we can see that there's a notion certainly that has been led in the first instance by Russia, where we don't believe in a rules-based system, we believe in a power-based system. And that sort of thing has snuck into American politics and even perhaps American foreign policy. But it starts with a lack of respect for our system and the rules that hold it together. Now, where did some of this come from? One of the things that struck me over time was it seemed to be that the rise of conspiracy theories happened to coincide with a sort of delegitimization, a lack of civility that showed up in our culture in various places. There are fantastic stories from the left and the right in America, whether it was, it started many, many years ago with the 1970s, where people started to think that the Kennedy assassination was an inside job of the CIA. And there were various left-wing theories about 9/11 being an inside job. And then we got to the really, the ugly ones that predominated later, that our government was being run by an enormous conspiracy against American citizens. And what happens is we delegitimized our politics in the country. They came first. We stopped believing in the dignity and the legitimacy of our leaders. And that was a terrible mistake. And of course, for people my age, we can remember the first great disillusionment with Richard Nixon. But the country seemed to gather its dignity back in the years of, say, let's say Ronald Reagan. Whatever you thought of his politics, Ronald Reagan brought a greater sense of dignity and warmth back to the presidency that hung in there for a while, but ultimately faded out and was replaced by a demonization of our political leaders, not only by the public and by conspiracy theorists, but by the politicians themselves. And what happened ultimately with that was delegitimization reaching from one branch, let's say the legislative branch, the executive branch, and tragically, as we'll see, into the judicial branch. So they say here how Pizzagate made its way into the courtroom. And I have real world experience with the idea that delegitimization, the lack of civility, the lack of a sense of the dignity of our institutions being destroyed makes its way into our courtrooms. How Pizzagate made its way into the courtroom, made its way into the courtroom from politics through family court. I spent most of my time as a complex civil litigation judge, but I ended my career on the bench with 2 years in complex family cases. And Pizzagate was very much in presence. The idea was that there was a pedophilic conspiracy running our family courts in my state. And accusation after accusation was made against judges, that what they were doing was in fact in a money conspiracy to sell children to pedophiles, and that custody decisions were bought and paid for, and people were being taken away from their parents, all to be part of this sinister scheme. And it had very real world consequences in my courtroom and the courtrooms of other judges, because we were constantly fighting just to keep the discussion on a civil plane, on a plane where we recognized each other's legitimacy and dignity, and that judges had to recognize the legitimacy and dignity of the people who came in front of them, including the lawyers and especially the parties, but they had to recognize and be civil toward the court as well, and to recognize the legitimacy and dignity of the judges. But it was very much in evidence and very much disrupted many of the cases that judges had, and this has a lingering effect to this day. Now, where else has it shown up? It's shown up in the weakening of the legal profession, because as I was saying, this stuff has leaked its way out of Congress, out of our legislatures, out of the executive branch, and into the courthouse. And this has affected, I think, the delegitimization of our institutions has affected the legal profession too. Because the legal profession was once held in a respect which is now a kind of a distant memory. As I mentioned, my father's years of practice, my father being a lawyer, me being a lawyer when I started out, it was a position of respect in the community. And the relationship between lawyer and client was particularly important, was particularly dignified, was particularly respectful, because people believed in the legitimacy of the legal profession, believed in the dignity of the lawyers, and believed in the importance of civility between lawyer and client. Many of you will know that that's changed over years. My father, in the first 45 years of his practice, had never had a grievance against him and never had a malpractice case against him. Only in the last 5 years of his practice did someone file a frivolous complaint against him, and it was astonishing to him. Now we know that relations between lawyers and clients aren't what they used to be, and malpractice claims have been on the rise. And that's, not necessarily because lawyers aren't doing as good a job as they used to. I think in many ways, lawyers are doing a better job than they used to. But the delegitimization, the loss of dignity, the loss of respect, the loss of civility toward the profession has made lawyer-clients relations into a greater realm of hostility. And this has affected, of course, relations among lawyers too. The relations among lawyers, as I mentioned before, used to be of the highest cordiality, the traditions of the bar, the relations among lawyers. And maybe it all just sounds old-fashioned and silly, but that old-fashioned and silly stuff used to cause lawyers to at least refrain from making the rivalries in court a blood sport. And so what happens now that, again, never used to happen, and I saw it as a complex litigation judge in particular, is that the party that wins a complex litigation suit almost always sues the other side. I'm saying, like, if a defendant wins a case against you, they turn around and sue you for whatever it may be called where you are, malicious prosecution, vexatious litigation, and they don't just sue the clients, they sue the lawyers. And that is an increasing phenomenon where once again, and many of these, of course, I'm trying to make clear, are frivolous claims. And of course, there might be legitimate ones. But it became in some of the most intense, complex civil cases I saw, an increasing phenomenon, and in my view, a very dangerous one. And it's infected relations between lawyers and judges. And of course, when I started out practice, the idea that you would make a complaint about a judge, even simply to other colleagues or to anywhere it might get out and tend to wound the dignity of the court, you just didn't do it. You explained that you disagreed with the opinion, you explained why, but you didn't vilify the judge. You didn't say that the judge was incompetent, and above all, you wouldn't say that a judge was unethical. But now, whether it's the lawyers doing it or their clients, attacks on judges are, I hate to say it, routine, in which ethics complaints are filed against judges all the time by lawyers. And in fact, I picked up, or I should say, opened the news this morning to find that the Chief Justice of my own state had just had an ethics complaint made against him by a litigant in a case that astonished me that this sort of thing was being made. It was brought by the lawyer. Now, relations among judges, witnesses, and parties, the awe is gone. The parties, witnesses, and judges used to have a far more clearly delineated relationship, to complain about the judge, to attack the judge, whether it's a witness doing it, not listening to the judge, not following the judge's orders, and parties vilifying the judges are much more common today. And I think that, again, the loss of the rituals of civility in those cases have had a major impact on that increase in misbehavior. And again, it's not because things are worse than they used to be. It's not because people are doing things wrong that they didn't used to do. It's the respect is gone, and using tools like grievances against judges is simply a way to get revenge. And in fact, it'd be nice to say I went through my career as a judge without having grievances filed against me, but I had one litigant alone who was a pro se litigant who every single time a ruling was made that he didn't like, filed a grievance against the judge. And so people ask you, why have you had 24 different grievances filed against you? Well, it's because I made 24 different rulings against a particular person. But again, the awe is gone even among the judges and the witnesses and the parties. And let's see. All right. So where is this stuff coming from? Obviously, there have been cultural changes I talked about before, but also let's talk now about the connection between civility and bias. And bias being the thing you walk into a relationship with another lawyer, the witnesses, the parties, and the court. It's something you start out with. So it's a matter, in my mind, again, of this bias that you walk in of delegitimizing the people you deal with in court. Somehow they don't deserve dignity. They don't deserve civility. They aren't legitimate somehow. And yes, sometimes that includes assumptions we make about people because of their race, their religion, their gender, etc. But it's far more than that. Relationships can be the product of bias when, for instance, let's say a prosecutor looks down on defense counsel and thinks that they're somehow illegitimate, that somehow we shouldn't pay them the respect and courtesy that we should pay others. Big firms facing off against small firms, employers in cases looking down on the workers that they sue, people villainizing corporate defendants no matter who they are, and plaintiffs and defendants delegitimizing each other. A perfect example being a situation where a defense counsel looks at plaintiff's counsel as always bringing a frivolous suit and never worthy of their respect. And it crops up throughout the litigation, throughout litigation, and we're going to talk about where it crops up shortly. So we're going to talk about it because we're now going to talk about specific challenges and suggested solutions during the course of a lawsuit. Let's talk about where lawsuits begin and what's happened with those. And that's in the drafting of complaints. And I find in them today troubles with the tone, the content, and the length, all of which have been affected by the decline, in my view, of civility. And I'll blame it on one thing that I think kicked a lot of this off, and that is the United States Supreme Court rulings in the Iqbal and Twombly cases that I'm sure most of you are familiar with. Those of you who practiced before Iqbal and Twombly saw the massive changes in tone, content, and length after the Supreme Court said that, well, the Supreme Court effectively made the complaint in a lawsuit front and center in terms of what gets the attention paid to it in court. And so let's talk about troubles with tone, content, and length. All right, let's talk about the tone first. I think that Iqbal and Twombly caused a lot of lawyers to lose sight about what a lawsuit is about. A lawsuit is supposed to be about a core value, a core societal value that has been violated allegedly by somebody. Usually I found that at the heart of many different kinds of lawsuits, there are things like lying, cheating, stealing, injuring other people. And complaints should be about those things and the facts that support them. But after Iqbal and Twombly, the core of a case got set to one side, and the tone, the length, and the content of the complaints changed. The tone of the complaints no longer focused very much on these core values that I talked about. The tone tended to be argumentative. A short, plain statement of the fact? No, an argument. Many times in the way of an attempt to delegitimize the person that's being sued at the greatest possible length in the most colorful kind of language, instead of making a short, plain statement of the facts. The content of complaints, of course, changed. Anybody who knows before Iqbal and Twombly would know that there was a big content shift after that. And again, I think what happened is you lost the legitimate focus of a lawsuit, and it became ritualized, it became formalized, it became the blood sport of complaint writing, that the battle is always over trying to knock somebody's complaint out and not trying to prove the legitimacy of your conduct in a case. And that's shown up in the way briefs, complaints are actually written today. A complaint today has become a combination of a brief with legal citations and legal arguments. It's become a series of exhibits where complaints in any level of complex case have exhibits attached to them. So you're putting on your evidence. And then tone-wise again, it turns into a closing argument. And that a complaint in a small case can go on for dozens and dozens of pages. And the length of the complaint is kind of the final insult of where Iqbal and Twombly has brought us. The length of the complaint has nothing to do with its merits. Again, we lose sight of a core value and the facts that need to connect to that core value. And when complaints go on for hundreds of pages, it sets a kind of atmosphere in which a case is going to proceed that I believe is not consistent with civility. It's an opening salvo instead in a battle over what doesn't matter, the form of a lawsuit, as opposed to what should matter, the substance of a lawsuit. And so lawyers in the early stages of a case focusing on the complaint tend to focus on the form of the complaint and not whether a person has some legitimate reason to be in court or not. So what can we do about drafting of complaints? Well, I've been saying it over and over again that the problem is with Iqbal and Twombly. And in a way, the rules still say not to do the things that people have done in response to Iqbal and Twombly. The rules in most courts are still a short, plain statement of the case and of the claim with the facts supporting it. And it's supposed to be simple, but it's not. But since Iqbal and Twombly, I think that we could amend some rules to try to make it more clear what complaints are not supposed to do. Complaints should not be allowed to have unnecessary case citations. Complaints should not be argumentative. Complaints should not be packed with evidence. They should contain what the rules have always said and nothing more, a short, plain statement of the claim and the facts that support it. And again, I think these things are causing the courts to focus on delegitimizing the complaint and the person that wrote it instead of focusing on the actual claim that a person has brought. So what can we do besides the rules? Judges can show leadership. The rules of in almost every jurisdiction allow courts to, a judge, to sua sponde take action about a complaint that isn't in the form that it should be in. And as a judge, I did that with a pro se litigant once, and I've certainly made suggestions and usually got a lot more cooperation from lawyers on doing it. You sit down with a complaint, you can't understand what it's about, and you say it's got to be rewritten. Let's work on what is this core value that you're claiming has been violated here, and how do we get at whether it was violated or not, instead of a complaint that's really about itself. And so under the rules that I was administering at the time, I sat down with the parties. One side had lawyers, one didn't. And the pro se litigant had simply copied a whole bunch of federal court lawsuits on the points that he was trying to make and stuffed them into a document that became probably about 200 pages long by just cutting and pasting the nonsense that's out there, which of course enraged his opponents and caused them to attack him for being frivolous. And again, the whole thing became an uncivilized mess about the language of the complaint. So what I did was simply say, all right, tell me what it is what are you saying these people did to you? What's the complaint? And it turned out there was really only one wrong thing this person was claiming. It was a defamation case. They said they had lied about him and damaged his reputation about an activity that he engaged in some years before. And I said, okay, you've got 5 people you've sued. Make 5 paragraphs and just say why you think these people did you wrong. Okay, back, the complaint was under 10 pages. Motion after motion stopped being made about attacking the complaint. And we were in fact able to move on from there. Okay, so now the next phase where we end up with these same kinds of problems that throw a case off track and throw the parties into violent opposition to each other, is serial motion practice. We have too many motions, preliminary motions in the cases, especially along the lines of the Iqbal and Twombly things I was discussing with you. What's filed in the motions is often too weak and they're too long. First of all, there are too many motions, and it's because we've decided that the case, again, is not about the case. It's about fighting. It's about skirmishing. It's about guerrilla warfare by motion. A defense counsel can know that they can really annoy their opposing counsel and frustrate their party and cause them a lot of money by filing one motion attacking the pleadings after the other, after the other, after the other. And this creates guerrilla warfare by motion, where expenses rise, tempers flare, and everything is talked about again, except that core value that somebody came to court in order to press. And the number of motions is something we can talk about when I talk about solutions, about what we can do about them. The motions are often also just plain too weak. It's part of the guerrilla warfare notion. Everybody thinks that they have to challenge subject matter jurisdiction today. This frustrates judges. This frustrates the other lawyers. This creates an atmosphere of frivolity, an atmosphere of illegitimacy, an atmosphere where one party is constantly claiming that the other just doesn't even have a right to be in court. Subject matter jurisdiction is vastly overused. People should have a right to come to court. They don't have a right to win. But what we've done is take some of these far-fetched legal claims and torture them into becoming about whether you even have the right to be in court at all. And this is what I mean by guerrilla warfare by motion and by far-fetched legal claims. And of course, factual misrepresentation has been very much on the rise in cases. So much so that in claims and in complaints and in motion practice today, too many judges just tend to overlook it and move on. I think that's a mistake. Whatever motions are, they're also way too long. Do you want to alienate a judge? Do you want to set a tone of hostility with your opposing counsel? Then file an endlessly long motion, which in so many cases, it takes you about 20 or 30 or 40 pages to get to where the substance of the discussion is. Consider the poor judge. The judge ends up seeing these things that are so long that they simply stack them up, and it takes them months and months to get to them because they realize they're 50 pages long and they're not going to be able to get to it for a long time. Consider your client in this circumstance, because the client has to pay for all this. And the client is the one who, along with so many other people in our society, are delegitimizing our courts. They no longer believe in them. They no longer believe that going to court is a tolerable thing. And motion practice, and the length of motions in particular, costs so much money that we simply alienate people by filing them. Judges, opposing counsels, and again, our clients who just see the bills adding up without them making any sort of progress. Don't worry so much about writing your briefs for your insurance company. Lawyers, in my view, ought to focus on winning cases. That's the best way to prevent a claim for malpractice anyway. Try winning. And a long brief isn't a winning strategy. So what can we do about that, about this motion practice problem? First of all, we can change the culture. Civility and brevity are kin. Time wasting simply raises temperatures. Time wasting simply raises legal bills. Raising legal bills raises hostility between the parties. Civility is a good thing in motion practice, because civility can lead to arms agreements, as I'm calling them here, where you can agree on the number, the length, and the character of motions. When you can agree on these things with an opposing counsel, you're limiting your client's cost. You're doing things which at least both sides have said to themselves, let's come together and agree about what needs to be heard in this case and get it heard, instead of simply beating each other over the head with serial motion practice as we do. A major point that I'd make throughout all of this in terms of civility is the leadership of judges. I think ultimately, so much of what's going on in courts has been because too many judges believe that they are sort of innocent bystanders during litigation. And unless something comes in front of them, that they don't have to decide it. It's easier that way. It's a kind of reverse civility, a kind of perverse civility, really, because judges think they're being kind to lawyers by not getting involved. But what actually ends up happening is it's like a boxing match where the referee steps out of the ring. And we're going to talk more about where the referee's out of the ring shortly. But leadership is needed from judges. Judges need to take their preliminary conferences in any case seriously where they do them. Some of them don't do them at all, but where they do them, they should be taking them seriously. They should be about trying to build a team approach from the very start of the litigation, setting a tone of civility, telling the parties the court has expectations for their civility and cooperation. And judges can seek agreement with the parties on the number, the length, and the character of motions. Where that fails, and this is a practice I engaged in, I made orders and it said that you must combine your attacks on the subject matter jurisdiction with your attacks on whether a cause of action has been created, with a claim that the court lacks personal jurisdiction. One motion, not three. Obviously, if the court has no subject matter jurisdiction, it doesn't have to decide the other two, but they're all filed at once. And that's a way a judge can help bring people together. And judges should keep people together with brief but regular remote conferences. Remote conferences like this one are very useful with a court and with busy lawyers and can be accomplished in a few minutes. Now, let's talk about where the referee is out of the ring and the boxers are just going at it. And that's abusive and uncivil communications that take place outside of the court. Brinkmanship in emails, texts, and telephones. Personal attacks on lawyers and clients that are outside of judicial earshot. So I think a lot of communication among lawyers today isn't necessarily the old-fashioned kind. I started with letters and went to emails. Who knows? Maybe text messages are the norm today, but maybe emails are still used, and often they're used as tools. Threats about in federal court, Rule 11. Every state court has a similar example. Claims about your claims are illegitimate. Your client is illegitimate. You aren't owed any dignity from me. You're the enemy. And I'm going to threaten you with other lawsuits, maybe the malicious prosecution or vexatious litigation. I'm going to threaten you. I'm going to promise to drag you in front of the judge. All of this usually over things that are sort of routine fights. And yet there's just so much pushing of it all in combative forms of litigation. Hopefully some of your experiences aren't like this, but all I can tell you is these things and the personal attacks exist more than they ever did in the past. Abusive and uncivil communications outside the court feature papering over of disputes. I remember when I was practicing in federal court, we constantly sent emails to each other about what motions we were going to file, what this was going to be, what was that going to be, and we weren't writing for each other and we weren't communicating with each other. We were writing to create paperwork so that we could use them and attach these things to our motions. We were papering over our disputes instead of actually resolving them. Now let's talk about why that's not a good thing. Why making a dispute personal between the lawyers and their parties is a mistake. And I like to believe that it certainly is, and it's because it has consequences. First of all, it has consequences for a defendant. A defendant is usually paying the bill. So you have, let's say it's a civil lawsuit and you're paying by the hour, and maybe you have a lawyer on the other side that's on a contingency basis. That lawyer, without adequate cooperation, without civility between the lawyers, can constantly punish the defendant by peppering them with motions, by demanding court hearings, by demanding their presence, by attempting to disrupt their businesses. The more civil it's kept between the parties, the better for a defendant who's looking to save money. I'd say civility is even more in the interest of the plaintiff. There are many plaintiff lawyers out there who believe they're on a kind of crusade against the bad guys. And it's all well and good to crusade against bad things. But when it's bad guys, you're demonizing your opposing counsel. You're delegitimizing the organization that you're suing. You're not just going after the other side, you're hurting yourself. I'll give you an example from my own experience in court. I was a litigator in the obscure business of ERISA, the Employee Retirement Income Security Act of 1974. And I was cutting new ground in this area in trying to make the argument that lying and defrauding pension participants is inconsistent with the fiduciary duties that ERISA put on people in its statute. And when I first started doing that, I was treated as though I was doing something wrong by bringing these obviously frivolous lawsuits against employers, because employers were doing something really nice by giving people their pensions. So they lied to them, so the people lost money as a consequence of the lies. There shouldn't be much you could do about it. I tried, in response to this kind of delegitimization technique, which, by the way, embraced some judges too, to respond by doing my best professional work and by trying to create bridges between myself and opposing counsel. And these bridges ultimately paid off for me, because what does a plaintiff want a defendant to do? They want the defendant to pay them money, usually, to settle with them, to give them what they want. And when you create boundaries of incivility between yourself and your opposing counsel, you're only making it harder for them to come together with you and give you what your client wants. I found as a technique in my cases that creating bridges of civility between myself and my opposing counsel was ultimately the linchpin to my successes in the field. And we were able to break new ground, and we were able to recover millions of dollars for pension participants, in part by just trying to create a civil relationship in which the legitimacy and the dignity of my clients was being respected by the other side. I co-counseled in a case once where the opposite was the prevailing approach. And this lawyer believed he was genuinely on a crusade against big bad corporate interests who were somehow inherently evil. There were no bridges of communication. There was no civility between the parties. It was a knockdown, drag-out fight. Whereas the cases I was sole counsel in, similar cases, sole counsel in, resolved in 3 or 4 years. The case with the lack of civility in it resolved after 22 years of fighting. And these were cases involving pensioners. These were people who had retired in their mid-60s and sometimes in their 70s, and they had to wait 20 years to get the money that was due to them. Needless to say, a person who was 70 years old, many of them hadn't even lived long enough to see the results. In my view, a lack of civility had a lot to do with the failure to bring that together. Obviously, the people who suffer most in the situation I just described are the clients. The clients didn't live long enough to see that particular fight play out, the one that I just described. And clients on the defense side are bleeding money constantly by making every court issue a battle. And so the clients are probably the biggest losers in all of those things. But the case on its own isn't the only reason. Winning the case or resolving the case for the client isn't the only reason for civility. The cost of making it personal also costs you for future relations. You're burning bridges instead of forging professional respect. In the area of the bar that I practiced in, ERISA, the bar across the entire country, it was all in federal court, very narrow stuff, and the bar across the entire country was small. And if you've got a bad reputation in that bar among your people on your side of the V or on the other side of the V, it hurts you in cases in the future. People wouldn't want to do business with you. People would know they were going to oppose you. People would want to destroy you because somehow you've been delegitimized. Somehow you weren't owed dignity anymore. And if you don't pay that dignity to other people, they're not going to pay it back to you. And that can hurt you as long as you're practicing law. Now, what do we do about it? I think that there are three things that ought to be done about the uncivil communication outside of court, and that are cultural changes, practice changes, and court changes. We have to change the way we think about this stuff. And cultural change is a start. From law school to bar associations, we have to start to remember what we're about. We're supposed to be about these core values that come into play with our laws. Core values are enshrined in laws. People come to court to vindicate them. People, when they do come to court, should be treated with respect and legitimacy so that they can make these claims and that we can focus on those claims. This sort of thing should be taught in law school. Dignity and respect should be taught in law school. Perhaps the history and traditions of the bar ought to be emphasized more in law school, the collegiality of it all, the dignity of it. The fact that being a lawyer is not simply being a businessman. And bar associations should emphasize this too. Lawyers are officers of the courts that they work in. They owe them a certain allegiance. Yes, their clients are important, but the entire system of justice, the legitimacy of that system of judgment, the dignity of that system of justice, the civility of that system of justice is necessary for the case you're in and the case you're in the future. And we've got to revive that culture. And we can do that in part by making changes in our practice, by making civility a successful business practice, as I just described, by making meets and confers meaningful. It seems to me in many cases, especially where there is a lack of civility between the lawyers, meet and confer requirements that are in practice rules often are simply pro forma. And you spend all your time fighting, you pretend you're having your meet and confer, and you're really just papering it over and aren't moving on to where you need to go. So making that a good business practice, practice where your clients can succeed and you can succeed in the future is an important change. Judges again. Judges are role models. Judges set expectations for the parties, and judges have the power to enforce civility among the parties, even in their outside of court communications. Simply by when people paper over these things and they spill in, that paper spills into the courtroom, judges can comment on the tone and character of the communications between counsel. Judges can model good behavior, and judges can punish bad behavior when they have to. Now, moving on, more specific challenges and suggested solutions. Incivility in discovery. This is the epicenter of incivility because, once again, the referee is out of the ring and the lawyers are swinging wildly at each other in discovery cases. And they do this in multiple ways. First, in written discovery. I think it breaks down the relationships between the parties. I think it is uncivil for parties to engage in the kind of discovery that we all know in civil litigation. And that is in written discovery. Every single question is objected to. Every single definition is objected to. And all of the definitions and objections, all the definition objections and substantive objections all sound the same. The parties are usually claiming that the question is overly broad, unduly burdensome, not reasonably calculated to lead to the discovery of admissible evidence, vague, etc. And these are cookie cutter things, and they've often followed requests by lawyers for extra time. And yet we get these cookie cutter and, frankly, I think, insulting responses to discovery. So I think that incivility in discovery is fed by the manner in which discovery has come to happen within the legal system in terms of the way people comport themselves. Incivility in meet and confers, I already touched on that early. When you have this tone of hostility between the parties, which is fed by the way answers come back in written discovery, you can't have a meaningful meet and confer. You're objecting to every single thing I asked you. You're giving me nothing, and you're just pushing us into this meet and confer without any notion of us ever being able to agree on something. And without, frankly, my suspicion that you actually want to agree with something. You're simply trying to drag it out and make it as bad as possible. So that's what's going on in those types of things. In depositions, it can be at its worst. Again, there's no referee there, but it seems like you're in court. And incivility bubbles over the top in these things because, of course, there is a contentious atmosphere. There's supposed to be the reservation of objections normally to trial, and yet parties will push the envelope and push the envelope by making objections that they shouldn't, by interrupting, and by just generally trying to make a person whose deposition is being taken as uncomfortable as possible. And these are mistakes of incivility that ultimately many times make a case harder to settle or harder to try. Now, solutions to discovery abuse. Again, cultural changes, practitioner changes, and court changes. Why law schools generally don't teach much about discovery, I will never know. When I was in law school, we only had a moot court that dealt with appellate arguments. And we had a moot court interterm, we used to call it. And we had competitions. And law schools didn't realize, apparently, that hardly any of the lawyers that are going to be made by that law school are going to be doing appellate arguments. Only a few of them. And they also didn't realize that many of them are never going to even actually get to try cases, that trials were becoming rarer and rarer. And yet today, and it's probably a good thing, but we do moot trial court work in law schools. I think that's good because I think there should be more trials. But what do most lawyers spend their time on? They spend it on discovery. Discovery is the biggest part of any case. And teaching good discovery practice, preaching courteous discovery practice, teaching practices of civility in discovery is a vital thing that law schools ought to be teaching. And practitioners need to change their ways here. They have to challenge the view that discovery is the main bludgeon of the case. The merits should be the main bludgeon of the case. Try to win on the merits. Your client did no wrong, or your client was wronged. Lying, cheating, stealing, injuring. These things ought to be the focus of your strategy as a practitioner. And you should facilitate discovery practice in order to make that all possible. And I think it's, again, a product of the problem we have with not trying cases. I don't know why, I'm not sure why cases don't go to trial in the way that they used to. But I think in part, it's because of the discovery process and the fact that it's a blood sport that costs so much time and so much money that you have these fighters in the ring fighting away without the referee. And then when it comes time for the main event, they're just too exhausted to go on. And their clients, by the way, are usually too broke. So courts again. Courts are absolutely vital to bringing some sense to the discovery disputes, the discovery of abuses, and the lack of civility in discovery. And I have a strong feeling about this subject, in particular about how discovery ought to be managed. And I practiced it myself for years when I was on the bench. And that is active court management of the discovery process, leadership and mentorship, explaining at the outset of a case how discovery is going to be managed and how it's going to work. I believe in court-led collaborative discovery. And by that, I mean something I used in practice, which is I started with the parties talking about that core of the case thing that I keep talking about. What is this about? Who's claimed that they've been wronged and why? And how are we going to get at whether that wrong existed or not? And how are we going to do it with discovery? And so what I would do when I was on the bench is I'd say, forget about written discovery. You're not going to do it. Here's what we're going to do. You're going to tell me what you want. And I would often know if it's a contract case. Okay, at the outset of the case, the parties are going to want all of their communications about the negotiations of the contract. So the judge puts it in an order, all the communications about the making of the contract, the negotiations, etc. You're going to exchange those documents, all drafts of the contract, all the documents that support damage of the contracts. And then I turn to the lawyers and say, help me out here. We're doing this thing together. Tell me what else you would like. And you get this collaborative energy going where you're rolling the case down the track here. And the parties tend to jump on board and start to say, well, okay, I know I'm going to want this. Well, why not this? And you have a discussion about it, and it gets worked out, and it goes in the court. It goes in the court order. And so you get discovery off and running with that. And then the judge can lead also by making themselves more available for discovery conferences. I did them every morning, and I would say, don't file any motions. Don't give me the interrogatories and production requests because I'm not letting you do them anyway. If I did, I'd say don't use them. Get on a remote conference and tell me, what is it you want from the other side? Tell me the thing you're after. Is it a document? Is it an admission of something? Tell me what it is you're after, and I'll rule on that. And usually in morning conferences or afternoon conferences, I might set a half an hour aside for these things. And I found that not only was I able to resolve things and move the case along, but I also stopped the fights over discovery. People stopped demanding the discovery conferences after a while because they knew they couldn't come in front of me and make requests that were illegitimate and insulting to the court and their opposing party the way they often did. The incivil exchanges between parties don't happen in front of the court. So a judge can show leadership that way. And then a judge must discipline in incivility. I had a situation in which a deposition kept going wrong, and a party's lawyer kept insulting and belittling and interrupting and disrupting a deposition in a case. I told them to do it in the court next time. Conduct the deposition with me sitting on the bench. And despite everything I tried to do to bring civility into the proceeding, this particular lawyer kept interjecting and insulting throughout the entire process. And that's where a judge's power has to come in play. When you do it on the bench like that, it's happening right in front of you. You're not reading a deposition transcript, and you really do know when someone crosses the line. It's the responsibility of a judge when a lawyer does cross that line to do something about it. Now, let's talk toward the end of the process about civility during trial. One of the things I find most uncivil about the relationships between parties when they get time for a trial to happen, in those rare times where the trial actually does happen these days, is the need to create a collaborative culture on exhibits, the customs and courtesies and objections, and more advanced involvement with judges. All of these three things are stuff that has been badly neglected and has led to a big mess, usually on the eve of the trial, with the problem with exhibits. A collaborative culture should be created with respect to exhibits. I used to do that by working with the parties. Again, you get this team approach. You get this collaborative approach where everyone's being civil to each other and cooperating toward a goal. And that goal is to reduce the number of exhibits by using admissions. Not the type that gets served like interrogatories and production, but court supervised ones, admit that the bank account had X dollars in it on a certain date. Don't admit 25 piles of bank statements when it's not in dispute what those bank statements say. Make admissions about it. Don't just say that a document can come in, stipulate that the deed shows that the grantor in the deed was Bob Smith. And I found that the battles over exhibits that happened during trials were eliminated. And so a trial that might have 70 exhibits might have 7. And I'm not kidding at how much reduced they are. This stops the fighting over the business record exception, the temperature increase in the courtroom that happens when someone messes up the business records exception, the anger of the juries or boredom of the jury as they have to listen to these people trying to lay the foundation for a document to be admitted into evidence that isn't even disputed. Talk about uncivilized. This stuff is not only uncivil, it's terribly boring. Admissions are a good way to fix them. Now, objections. Objections are another thing that jurors and judges hate because it's all full of speeches and all full of anger. And too many times, a judge doesn't intervene. Now, this is a piece of leadership. Judges should enforce this, and lawyers as officers of the court should understand their duties in this regard. Don't make speeches, show no anger during objections. Most people's rules and the parameters that control the judges in these cases allow a judge to say, look, stand up when you object. Always stand up when you object. State the name of the objection succinctly. It's leading. You don't have to say why. And if the judge can rule on it, the judge immediately rules on it. If the judge needs to know more, the judge asks no more, no less. Court-led collaborative discovery means, again, that you're going to be there at trial with material that has been ordered by the court many times and not simply by the parties. Whatever you do during making of objections, be polite, be professional, be brief. Now, court leadership, again, as I've been saying over a long time, is critical in this area. Judges have to discipline incivility when it happens during a trial. Many times the best thing to do is to call the lawyers up to the bench and to say that the manner in which you're making your objections is improper, or counsel, remember to stand up when you're making your objections. Court should oversee the use of the trial admissions at trial. You can coach and explain to lawyers how you're supposed to use those admissions, adhere strictly to the objection rules, and kick off the trial like anything else with a collaborative conference. It would be nice if that collaborative conference was about how to streamline the trial, how to use admissions of facts to skip over things that bore and annoy judges and juries, rather than another thing that is an abusive practice, which is, of course, the serial motions in limine, the dozens of motions in limine that a complex case will generate, and the half dozen or so that a non-complicated case will generate, many of them baseless, and accompanied by motions for directed verdict during the trial and the rest. Judges should see that these things are consolidated. Legitimate issues get raised. Maybe they get raised at a certain time, certain place, in a certain volume. Motions have to be made, but they don't have to be made one after the other, and they shouldn't be tolerated when they are uncivil. Now, lastly, there is a proposal that judges and lawyers can add to the civility that goes on in court by actually making changes, formal changes to the rules. And there's been a proposed new rule of professional conduct, 8.4.2, which is to prohibit incivility under disciplinary rules, which states that in representing a client, a lawyer shall not engage in incivility in the practice of law or related professional activities, and that for purposes of this rule, incivility means significantly unprofessional conduct that is abusive or harassing and shall be determined on the basis of all the facts and circumstances surrounding the conduct. Now, it's my understanding that this was proposed by the bar in California, and the result was to not make this a disciplinary rule, and that California has adopted instead an oath and affirmation, an annual oath or affirmation that you have to promise to engage in civility, to proceed with civility in the profession. I think the oath is a good thing. I do agree with the concerns that maybe the rule here could be difficult to implement because maybe a lack of definition is a problem in some ways. But I'm not sure that no rule at all is a good thing either. I think it needs further study, but it struck me when I was reading it that at least if it ultimately dealt with extreme unprofessional conduct, that at least you'd be able to get rid of frivolous claims or frivolous attacks at the time of the frivolous attacks at the time they're filed when you use extreme, because then we have some understanding of what extreme is in unprofessional conduct. So I think another go should be given to this, but I do believe that everyone should constantly bear in mind and be educated to the need to civility in court, and ultimately this rule or other rules ought to ultimately police it. So for more information on this subject, I spent a great deal of time and effort writing about how efficiency can be brought into court proceedings. And I think efficiency encourages civility in court. And if you're interested in that subject, you're interested in more details about some of the techniques that I was suggesting here about how to de-escalate the confrontations in court by efficient use of judicial leadership and the rest of it, read The Common Flaw, Needless Complexity in the Courts and 50 Ways to Reduce It. It's a fun read, I hope, and you might find it helpful. And with that, I say to you, thank you very much for your kind attention. I wish you all the best in your practices, and may civility long be your companion. Thank you.